Respected colleagues, my dear fellow members of the bar, young advocates, and my dear friends, good morning to all of you. I am here before you today not merely as an individual advocate, but as a member of a profession which I have had the privilege of serving more than 4 decades. And I speak today with deep pain, disappointment, and a sense of institutional hurt on the controversy of Bar Council of India NALSR fiasco, impact on the legal profession, a warning to the bar, and a question of institutional accountability. My friends, the controversy involving the Bar Council of India chairman and the students of NALSR University of Law is not, in my view, merely a dispute about convocation. It is much bigger than that. It concerns the dignity of the legal profession, the independence of the statutory institutions, the constitutional rights of young law students, and the manner in which the power must be exercised. My friends, and therefore, I believe we must speak not with hatred, not with personal hostility, but with constitutional courage. My friends, let us first acknowledge what the young students of NALSR have done. They expressed their disagreement, they questioned, they protested peacefully. They did not surrender their conscience simply because the person concerned was the Chief Justice of India. Whether one agrees with their position or disagrees with it is a secondary. The fundamental question is, did they have the constitutional right to express their opinion? My answer is an unequivocal yes. In a democracy, disagreement is not disobedience, questioning is not disrespect, peaceful protest is not rebellion, and dissent is not an anti-nationalism. These are the very freedoms which lawyers are expected to defend throughout their professional lives. My friends, what deeply concerns me is what reportedly followed. A direction was issued from the chairman, Bar Council of India, on the Bar Council of India letterhead concerning the enrollment of 2026 graduating students of NALSR because of the controversy surrounding their objection to the presence of Chief Justice of India at their convocation. The direction was subsequently withdrawn by the BCI Council. But colleagues, let us pause and think. What would have happened if the students have remained silent? What message would they have sent to every law student in India? That if you question a powerful constitutional authority, your professional future can be put at risk. That if you exercise your freedom of speech, a statutory regulator can turn against you. And that if you disagree with those in authority, you must first think about the consequences to your career. If that becomes a message, we have failed the next generation of lawyers, my friends. I want to say something very clearly, and I say it with respect for the office. The Bar Council of India is not the personal fiefdom of its chairman. The chairman is the occupant of an office. He is not the owner of the institution. The BCI is a statutory institution. Its powers come from the law. Its authority comes from the Advocates Act. Its legitimacy comes from the confidence of the legal profession, that is bar associations. Therefore, no individual office holder, however powerful, however influential, however experienced, can treat the BCI as though it were a personal instrument. Institutions must be bigger than individuals, my friends. That is one of the basic lessons of constitutional democracy. My friends, this episode raises several questions which deserve answers. Who authorized the original communication? Was it a decision of a competent body? Under what statutory provision could such an extraordinary direction concerning the professional future of an entire graduating class be issued? Was there a collective institutional decision? What safeguards exist to prevent an individual office holder from exercising powers beyond the authority conferred upon him? These are not the personal questions, my friends. They are institutional questions, and therefore they must be answered institutionally. The Chief Justice of India's intervention is very significant. The intervention of CJI is also important. The reported observation that what happened at NALSR was essentially a dialogue between the students and the Chief Justice deserves a serious reflection, because, my colleagues, That is exactly what constitutional democracy requires. A student can question a chief justice, a citizen can question a prime minister, an advocate can question a judge, a journalist can question a government, and an institution can be questioned by the people it serves. That is not the defiance of the authority, that is the accountability. So today it is a law student, my friends. Tomorrow it may be an advocate. The day after tomorrow it may be a judge, and eventually it may be any citizen. If we allow professional consequences to be attached to the peaceful dissent, we will create a culture of fear, and law cannot flourish in an atmosphere of fear, my friends. The legal profession was born to challenge arbitrary authority. Our courts exist precisely because somebody must be able to say, no, this action is not lawful. If the bar itself becomes intolerant of disagreement, who will defend the constitutional liberty, my friends? So, I acknowledge the subsequent expression of regret and apology by the BCI chairman Manan Misra. There is absolutely no shame in apologizing. In fact, I would say that an apology is a sign of strength, not weakness. But an apology cannot by itself close the institutional question raised by this episode. We need to know how such a decision came to be made. We need institutional safeguards. We need transparency. We need accountability. And above all, we need to ensure that nothing similar happens again. So, a word of about political affiliation. My friends, there is another issue which we cannot simply ignore. The chairman of Bar Council of India, Manan Misra, is also a sitting member of a parliament elected on a political party ticket. There is nothing inherently wrong with an advocate participating in politics, but when a person simultaneously occupies a powerful statutory position regulating the legal profession, the independence and even the appearance of independence of that institution becomes extremely important. The BCI must never be perceived as an extension of a political party. It must never appear to be functioning to please political masters, and it must never become a platform for advancing personal political interest, because when the BCI independence is questioned, the credibility of every advocate in this country suffers. My friends, my friends, I say this with a heavy heart. When a highest statutory body of our profession becomes embroiled in an episode of this nature, we all suffer. We hang our heads, not because we are responsible for the conduct of an individual office holder, that is BCI chairman, but because the institution represents all of us. The Bar Council carries the name of the legal profession. When its dignity is damaged, our collective dignity is affected. I have spent more than 4 decades, my friends, in this profession. I have seen advocates challenging the governments. I have seen lawyers standing up for prisoners. I have seen the bar defending minorities. I have seen the advocates fighting for civil liberties. I have seen young lawyers take courageous positions even when they knew there would be consequences. That is the tradition of our legal profession. We must not lose that tradition, my friends. Then, therefore, I want to congratulate the students of NALSR. They have demonstrated something valuable. They have shown that the Gen Z is not necessarily a generation that bows before authority. They have shown that the young citizens can disagree respectably and peacefully. They have shown that the constitutional rights are not merely words in a textbook. They can be exercised in real life as well. And when students of NLSU, IU, Bangalore and others stood in solidarity with NALSR, they demonstrated another important principle, my friends. An attack on the freedom of one academic community concerns all academic communities. An attack on the freedom of one citizen concerns all citizens, and an attack on the independence of the one institution concerns all the institutions. I therefore regard the withdrawal of the BCI directive and the subsequent expression of apology by the BCI chairman as a victory for the constitutional democracy and for the courage of young law students. But let us not celebrate merely because one order has been withdrawn. Let us ask ourselves, what have we learned from this episode? Have we learned that the statutory institutions must function according to law? Have we learned that the office holders must exercise restraint? Have we learned that the students cannot be intimidated? Have we learned that the professional rights cannot become instruments of retaliation? Have we learned that the bar must remain independent of political power? If the answer to these questions is yes, then something positive will have emerged from this controversy. My friends, and now I come to the most difficult point, the BCI chairman Manan Misra's point. In my respectable but firm view, considering the damage caused to the credibility and dignity of the legal profession and the institution of Bar Council of India, the chairman of BCI should seriously consider voluntarily stepping aside. I do not say this out of personal animosity. I say it because sometimes resignation is not an admission of defeat. Sometimes resignation is an act of institutional responsibility. It can say, the institution is bigger than me. The dignity of the bar is more important than my position. I am willing to make a personal sacrifice to restore institutional confidence. That would be a powerful message if BCI chairman resigns his post. Then the real issue is not Manan Mishra alone. The real issue is the institutional structure. We need BCI which is independent, transparent, accountable, collective in its decision making, respectful of dissent, and completely committed to the rule of law. The BCI must regulate the profession, not intimidate it. It must protect the dignity of the advocates, not diminish it. It must guide young lawyers, not threaten their professional future. And above all, it must defend constitutional values, not become an instrument of power. So let us remember, my friends, we are lawyers. Our first loyalty is not to any individual. It is not to any political party. It is not to any government. It is not even to a particular judicial officer or a judge. Our first loyalty is to the constitution and rule of law. We must have courage to tell the government when it is wrong. We must have the courage to tell the judiciary when something requires reconsideration. And we must have the courage to tell our own institutions, the Bar Council of India, when they cross the line. And yes, we must have the courage to tell our own bar councils when it is wrong. Because silence in the face of institutional wrongdoing is not neutrality. Sometimes silence itself becomes an accomplice. So, my friends, let us therefore not remember the NALSR controversy merely as a confrontation between students and the BCI. Let us remember it is in a movement where when young law students reminded the legal profession of something fundamental. Power must answer to the people. Authority must answer to the law. Institutions must answer to the constitution. And students must never be afraid to ask questions. That is the India which our constitution promises. That is the India for which generations of lawyers have fought. And that is the India we must leave for the next generation. My dear friends, the BCI belongs to the bar associations. The bar belongs to the constitution, and the constitution belongs to the people. No individual is bigger than any of these of institutions. Let us therefore stand with the young students of NALSR, not necessarily because we agree with every position they have taken, but because we defend their right to take that position. Let us demand institutional accountability without hatred. Let us demand independence without fear. Let us demand reform without bitterness, and let us restore the dignity of the institution and the legal profession which represent us all. Because when a young law student stands up and says, I have a right to disagree, the correct response from the legal profession should never be, how dare you? It should be, you have the right to speak. We will defend that right. That is the spirit of the constitution. That is the dignity of the bar. And that is the legacy we owe to the next generation of advocates. Jai Constitution, Jai Democracy, Jai Bharat.